I'd like to call the Subcommittee on Joint and Permanent Rules to order. I have to say that I have been looking forward to this. Senator Drazkowski, I know you are looking forward to this as well. Just in terms of the lay of the land for today and the process we're going to use. Today is a day for us to be introduced to the ideas that are coming from a variety of places. We're not going to take action today. Today is the day for us to hear the proposals, to perhaps ask some fundamental questions, but not get into debate. We are going to come back for a second meeting. There'll be time in between this and the next for people to talk together, as we do as members of this body, to talk together and to understand a little bit more deeply what the ramifications might be. That might be discussions among members, but I think it's also important that it is among members and the staff who have expertise in the body, in the function, in our customs, in our practices. And so today really is a day for us to consider, to contemplate, to ask some basic questions, knowing that we're going to come back for a second discussion. Does that make sense for everybody? We're not planning to act. Senator Rest.
Thank you. Just another question. Is it at least a goal to recommend to the Rules Committee some changes that then would need to go to the chamber floor to be adopted or rejected?
So my process, if you will, would be for us to do this work today, that we would come back together again as a subcommittee to then wrestle with what we have been, what we've considered. That would then go to the Rules Committee.
Yes, okay.
And then that would go beyond that with recommendation or not from Rules onto the floor.
And they don't have, Madam Chair, and they don't,
Senator Rest.
they can decide not to take any action at all. I mean, this is just a report to them. I'm just, the expectations, I think, need to be clear all along the way.
All right.
Thank you.
Very good. Without further questions about what we're doing today on this beautiful Friday before noon, when the sun is out, I will say, welcome to the committee, Secretary Bodden. Members, before us, we have a document, it's SR 029-5. And this is the first document that we're going to go through, which is, I understand Secretary Bodden set up proposals primarily from our staff. And you can correct me on that if you'd like. Welcome.
Thank you, Madam Chair. Hope the microphone is working here. I never know if these are on. Thank you. So yes, the document that represents the staff proposal is the SR 029-5 document. You should have that in front of you. What this represents, it's the product of some work during the interim. I worked together with the front desk staff and Senate engrossing to prepare a set of recommendations that really, in effect, update the rules. There are a variety of changes that are made here, ranging from eliminating obsolete language to rules that are really no longer used. The intent is technical in nature and just to make the rules easier to work with. A word about the process. We developed a set of recommendations, basically from the front desk staff and Senate engrossing, and then worked together with Senate Counsel, who made some additional recommendations that you'll also see represented in this proposal. I took those recommendations and shared them with leadership, with the majority and minority leader and with leadership staff, as well as the Senate President. At every stage of the way, I've indicated, there's no pride of authorship in any of this, and if there's anything that seems objectionable or doesn't make sense, or for whatever reason people aren't comfortable with including, I've asked for that feedback, and along the way have removed a couple of provisions. So that's how this document has reached this stage, and then I can walk you through those changes. I'll try to be relatively brief. There's a lot of material here. Please interrupt if there's anything that seems to require a little more explanation. One, at the outset, I'll say I think a large part of the changes you'll see in the document reflect the the elimination of the process for the committee of the whole. It's been used once in the Senate since 2010, and there appears to be really no momentum or interest in using that. If, and I'll phrase it like this, I think it's kind of it could be a leadership decision made at the beginning of a biennium to employ that practice. It would be a simple matter to bring it back into the rules if there were a need. But right now, I think the way that process reads in the rules, and you'll see when you look through the document, there's just an enormous amount of additional language that does not make the rules any easier to comprehend, that seems to serve no useful purpose.
Madam Chair.
Senator Rust.
So by the committee of the whole, you mean that we would use general orders and then come back and vote on the calendar another day? I mean, that process?
Secretary Bodden.
Madam Chair, so Senator Rest, the process that remains, there would be a document labeled general orders that is in effect a list of bills that have been passed from committee and sent to the whole Senate. Special orders really becomes the working tool for dealing with consideration of Senate bills.
Thank you.
Thank you, Secretary Bodden. If you'd like to proceed.
Thank you, Madam Chair. So beginning with Section 1, you'll just see a brief addition, some additional language there that clarifies that we will work with the Senate will use the most recent version of Masons. The NCSL and the American Society of Legislative Clerks and Secretaries update Masons every decade. There's a lengthy process to do that, so it just would be, and sometimes it's not immediately clear which version has applied in the past. This is just clarifying language for that purpose. Beginning on the bottom of page 1, from lines 1.31 going forward, there's some stricken language that refers to a process that hasn't been used in many years for the introduction of bills in the interim between the odd-numbered and even-numbered year. Again, hasn't been used, don't see the need to include it in the rules. On line 2.6, you'll see the first of many shall to must changes. That's obviously a drafting convention. In short, I don't think there's any legal distinction between the two, but many readers prefer must and believe that's easier to comprehend. So that's a recommendation as well. Moving
Senator
to page-
Pappas.
I'm sorry, Madam Chair, it's just this whole move to must, it's so funny because it sounds so harsh to my ears when we're so used to using shall, which has a much more genteel feel to it. So it'll take some adjustment.
Thank you, Senator Pappas.
Madam Chair and Senator Pappas, I admit to being agnostic on the question and take the guidance from Senate Counsel on this one. So moving ahead to page 3, Rule 5 contains some clarifying language that is intended to illustrate to clarify the number of votes needed to remove a bill from committee after committee deadlines. What is added here clarifies that if a bill is in a committee that is not subject to deadlines, it's clear that a majority of the whole Senate, i.e. 34 votes, is what's needed to pull that bill from committee, not the 41 votes that are needed for bills in committees that are subject to deadline that haven't met deadlines. So a semi-complicated concept, but hopefully this language will make that much more clear. Rule 6, beginning on line 3.23, is intended to clarify the situation that could arise when the Senate organizes itself, and this rule is invoked to send a resolution to a Rules Committee that has not yet been established. It's kind of a chicken or the egg question. Really, you need a Rules Committee in order to be able to refer a resolution to it, and if the organizing resolution hasn't passed yet, hasn't been adopted, it's difficult to do that, if not impossible. Let's see, I'm just turning the pages here. I'll next take you to page 6. The language in Rule 10 reflects, it's just modernizing language that refers to committee or majority and minority groups. That's intended to read as caucuses. The uniform criteria referred to in the stricken Rule 10.3 have not been employed for many years. It's not precisely clear how that would operate. I could elaborate on it, but again, this is another rule that really has not been used and no longer seems necessary for that reason. I will move past conforming changes that I've already discussed, such as the change from group to caucus and the shall to musts and rules as we move through here. Next, I'll take you to Rule 12, shown on page 7. This strikes a reference in the committee meeting rule to caucuses of the Hennepin County, Ramsey County, or St. Louis County delegations and requires those to be open to public. I'm not aware and haven't talked to anyone else who's aware of meetings of those groups as such, and I don't think the open to the public requirement applies to my knowledge. Next, there are some obsolete references in the remote voting provisions of the committee meeting rule to COVID-19 that are stricken. And then clarifying language on line 7.21 to 7.22 that is intended to make it very clear, and this is the guidance chairs have been providing, that a member must be visible when speaking or voting. On page 8, at the top of page 8 in Rule 12.3, there's some language that modernizes, reflects the current practices the Senate uses. There are no longer bulletin boards available for posting. That's all done on the internet. And the last piece of additional language you see on 8.8 to 8.9 makes it clear that putting a notice on the committee listserv will satisfy the requirement you see in the rule to give simultaneous notice to all known proponents and opponents, rather than guessing at who those are. Providing that through the listserv is deemed to meet that requirement. In the middle of page 8 on line 8.22, there is more affirmative language that directs that minutes must be taken, which they are, for meetings of standing committees and subcommittees, and must reflect every action and vote. This rule appears to make it, the existing language is a little hard to understand and seems to suggest that a member would have to request that. That is, in fact, the practice and requirement for all committees currently.
Senator Rest.
Thank you, Madam Chair, and Mr. Boddern. I just wonder if there are more general and enduring terms than internet and website, because we don't. We can anticipate new technology, I think, without having to go back and change obsolete words like website and the internet. And I just would like you to give some thought to that and maybe talk to our IT people if they have ideas of a more general descriptive term that will not require changing common terms that are used today, but may not be 2 years from now. And I think it's been a long time since we've taken up permanent rules, and we're finding other kinds of obsolete things. So if we have a description of technology available or something, that might be, we could do that, we wouldn't have to revisit it.
Secretary Bauer.
Madam Chair and Senator Rest can certainly work with Senate Council and attempt to come up with some language that might be more generally applicable.
Senator Drazkowski.
Thank you, Madam Chair, and I don't want to step on the toes of council because they know this stuff better than I, but just as I read on 8.32, would it read better if we struck the word no and said a Senate committee or subcommittee must not permit? Would that read easier and less confusing?
Mm-hmm.
Secretary Boddern. A note?
Madam Chair and Senator Drazkowski, thank you for that observation. I'm looking at that and thinking perhaps there's a better way to word it.
Thank you, Madam Chair.
Appreciate that.
Please proceed.
So taking you to the top of page 9, Rule 13, this rule provides a default if the Senate adjourns without setting a precise, it adjourns from day to day without setting a precise time for when to meet. The existing language really leaves some ambiguity because it refers to the next legislative day, which is not established until the Senate meets. So this change would direct that the Senate would have to meet at 11 a.m. on the following calendar day if it adjourns without setting a time, and obviously would exclude Sundays. The change to Rule 14 that you see below that is really intended to simplify the requirement that
Madam
a
Chair.
member must inform the president of the member's geographic location just by supplying the words city and state.
Secretary Bodden. Senator Rest has a question. Senator
Thank you.
Rest.
On 9.1 and 2, on the following calendar day, excluding Sundays, but some sessions, including this one, is going to come very close to running out of legislative days. And so, I mean, they could say on the following calendar day, given that the legislature or the Senate is legally able to be called into order. I mean, if we run out of days, we can't follow this rule if we're done with the number of days, calendar day or legislative day. Just to ask you to think about a temporizing word or two. It has to be as long as the Senate is in session.
Secretary
Madam Chair
Bodden.
and Senator Rest, I'll chew on that one
Okay.
and think about a way to address that hypothetical.
Thank you.
So taking you to line 9.24, there's a change made to Rule 14.4. What this change does, you can see the new language that states that a tie vote sustains the decision of the president. This is what Masons provides and what has been the practice of the Senate for a long period of time. Incorporating this into the rule will save the trouble of references to Masons and a description of Senate practices and just make that practice more straightforward. But it certainly is, and has been for a very long time, the Senate practice. I'm just turning the pages slowly here to make sure I don't miss anything.
Secretary Bodden. Secretary Bodden, Senator Rest has a question.
The rule change under 14.1 does not require the president to publicly announce where the city and state where someone is voting from currently, right? And this will not change that. It will still be just a notice to the president. It will not be a notice that is publicly proclaimed.
Secretary Bodden.
Madam Chair and Senator Rest, that is correct. There's no requirement to affirmatively announce it.
Senator Drazkowski.
Thank you, Madam Chair. So, Mr. Bodden, on that discussion, would that information be available for members to discover?
Secretary Bodden.
Madam Chair and Senator Drazkowski, that's correct. That knowledge is in the possession of the president, and if a member asks the president, I think the president would
Thank you.
need to provide it to them.
Thank you.
Moving ahead to page 12, there's a small change made, really, I think, just to emphasize, to separate a couple of items in Rule 17. The language referring to demonstrations is clarified to be consistent with statute and presented as a separate item in the list of items that apply to decorum in the chamber. Beginning at the bottom of page 12 in Rule 18 and shown on the next page as well are a series of changes that reflect the elimination of the committee of the whole process. So these items are stricken and they're repositioned elsewhere in the rules. Let's see, moving ahead to to Rule 19 on line 13.13. The requirement to ensure that messages are promptly delivered in the chamber has really been a responsibility of the Secretary of the Senate through the pages and is more properly contained in this portion of the rules. You'll see it later is stricken from requirements that apply to the sergeant. At the bottom of page 13, there are changes to Rule 22 that would preserve the document that is known as general orders. The Senate, in other words, will keep that list of bills that have been referred from committee, but general orders no longer remains an item of business, an order of business. Moving through basically everything you see In the middle of page 14, the stricken language for Rules 23 and 24 eliminates the committee of the whole process. Another component is the elimination of the consent calendar. That's Rule 25. That's another item that has been used very infrequently and no longer would convey an advantage if the committee of the whole process is eliminated. One advantage that's the consent calendar had was to accelerate the consideration of a bill, but that's obviously available through special orders as well. Then moving ahead to, Rule 26 is more conforming changes related to the elimination of the committee of the whole. Taking you to Rule 29, shown on page 16, there's new language related to a motion to adjourn sine die, which is distinct from a motion to adjourn. It is given separate treatment with respect to debatability, amendability, and so forth. That is a Mason's provision. It has been the Senate practice, and I think it's helpful to include it in the rules. So again, eliminating the need to refer to Masons and take more time. It just makes it very plain to see. Looking ahead to Rule 32 on page 17, those are just conforming changes related to the elimination of the committee of the whole. On page 18, line 18.5 is a conforming change related to the elimination of the consent calendar. Rule 35, the language shown beginning on line 18.19, contains kind of a complicated concept when the president elects not to rule on a question of germaneness and puts the question directly to the body. This becomes difficult to explain in terms of what a red vote means and what a green vote means. The language you see here is intended to clarify that and to clarify what happens in the event of a tie vote. But there's really no better way to explain it than just to read what the president must inform the body of. Again, when a question of germaneness is put directly to the body for its consideration without a previous ruling by the president would explain that a yes vote means that the point of order on germaneness is well taken and therefore the amendment is not germane, and that a no vote means the point of order is not well taken and the amendment is germane. And a tie vote would mean that the point of order is not well taken and the amendment is germane.
Senator Rest.
Thank you. And this is the same approach when a motion is made to challenge a ruling of the Senate. If it's a tie vote, the point of order, explain that again, if you would.
Secretary Bodden.
With the president and how it's different if it is with the whole body voting.
Madam Chair and Senator Rest, and I think I'd have to take a moment to find that, but there is we looked at that rule previously, and it clarifies that a tie vote sustains the decision of the president when there is an appeal from the decision of the president.
And a tie vote, Madam Chair, Ms. Potter, and a tie
Senator
vote
Rest.
by the body also sustains the point of order is well taken or is not well taken. So it's different.
Secretary Bodden.
Madam Chair and Senator Rest, it's correct that the language you see here would, in effect, a tie vote would not sustain the point of order. The way I think about it, maybe kind of from a more legal perspective, is who has the burden affirmatively. If an amendment is offered, it's presumed to be germane and would require a majority of votes to demonstrate that it is not germane.
But Madam Chair, Mr. Bodden, when
Senator
the president
Rest.
makes that ruling, and it is the vote to uphold or not to uphold that ruling, sides with the president on a tie vote, right?
Secretary Bodden.
Madam Chair and Senator Rest, that's correct.
Okay.
Yes. Moving ahead and turning the pages slowly here to make sure I draw your attention to the changes. The next item is on page 20, Rule 39. This is another item in the change to that you see in the language that remains. Again, reflects Senate practice and what is written in Mason's and just brings it into the rule. And a president determines whether a division can be made in the first instance, and then the author of the amendment or resolution that is divided is permitted to determine which portion is taken first. The language that's stricken on,
Senator Rest.
I'm sorry, I am going to keep asking questions just to understand because I haven't seen these before. So the president determines whether a motion is divisible, usually an amendment, and then the author determines which portion to vote on first. Is this an issue that comes up in Masons, and is it identical to what is recommended in Masons, or is it something different?
Secretary Bodden.
Madam Chair and Senator Rest, you are correct. Masons addresses this. The Senate has followed Masons. That's been the practice. So yes, to your question.
It's affirming, Madam Chair and
Senator Rest.
Mr. Bonner, it's affirming that the practice we have been using coincides with what's recommended in Masons, but now it's going to have a higher order of meaning by being in Senate rules.
Secretary Bodden.
Madam Chair and Senator Rest, that's correct.
Thank you.
Please proceed.
Taking you to line 20.7, you'll see stricken language, what would be formerly Rule 39.2. This provision has not been employed for decades, to my knowledge, referred to or used in any way. And I think if you asked a variety of staff and others who've been here for quite a while, really what they would have to do is guess at the meaning of this provision. So we're recommending removal. Taking you to the changes you see in Rule 40, which refer to the procedure for voting. And this is voting as it occurs in the Senate chamber, as distinct from the previous rule on voting that applied to committees. You'll see the stricken language deletes the reference to a peacetime public health emergency. And then there is language at the bottom of the page that affirmatively requires remote votes to be recorded in the journal. Again, that's the present practice, but this just puts it into the rule to make sure the Senate continues to follow that practice. Rule 41, the change you see there is another conforming change related to the elimination of the committee of the whole. Same on line 21.16. The changes you see to Rule 44 are intended to ensure that the careful engrossing occurs in every instance. That's the first portion of it. And then you'll see on lines 21.28 to 21.29, the existing language is a little ambiguous about exactly who is required to do this and assigns the duties to the secretary and engrossing secretary. The language you see on line 21.30, lines 21.30 and 21.31 has been moved into this section. It really works better to include it in the rules for engrossing rather than assigning it separately in a rule later where it's a little less logical.
Thank you, Secretary Bodden. Senator Rest.
Thank you, Madam Chair. So on 28 and 29, does that mean that both have to give the direction, or should it be either or just plain or?
Secretary Bodden.
Madam Chair and Senator Rest, I think both would need to agree. I think we know how that would work if there were a disagreement, but it's just to affirm that the engrossing secretary needs to be involved in that.
And Madam Chair,
process.
Mr. Bodden, is that current practice that both of you or people in those two positions have to agree on the together must exercise the authority about engrossing?
Secretary Bodden.
Is that common practice, current practice?
Madam Chair and Senator Rest, I don't think there's,
Or is it
the
informal?
secretary and the engrossing secretary do not confer in every instance. I think what this change is intended to convey is that the engrossing secretary will work together with the secretary to ensure that it is done properly.
Thank you.
Thank you. Please proceed.
So, Madam Chair, I will next take you to the changes shown on lines 22.20 and 22.21, that's another conforming change related to the elimination of the committee of the whole that is proposed. Then at the bottom of page 22, the subcommittee on conference committees meets fairly, well, I suppose somewhat frequently and more informally than any other subcommittee or committee. This makes it clear that it's not required to follow all the procedures contained in Rule 12 when it does that. Taking you to Rule 47. Again, these are conforming changes related to the elimination of the committee of the whole. And then on line 23.17, there's an additional change here. Just there are other provisions in rule that make it clear, making bills and other legislation available through electronic means will meet the printing requirements that are contained elsewhere in the rules. This does the same thing.
Madam Chair.
Senator Rest.
Madam Chair, Mr. Modern, how often has there been an issue about a bill that is, I realize it's, forget the updating, but part of it on lines 23, 4, that's on general orders or on the table? Is that just a technical change there?
Secretary Bodden.
Madam Chair and Senator Rest, yes, I think the language you're referring to on 23.4 is just
Got it.
purely technical and intended to convey what, the significance of being on the table, laid on the table. So I'll next take you to the changes that you see in Rule 51 on page 25. The language you see from 25.7 to 25.9, we just finished discussing and was moved to the section on engrossing where it really, I think it fits better there. The other changes you see here are purely technical. There are changes in Rule 52 that we've discussed on line 25.25, the responsibility for delivery of messages in the chamber. And the language in 25.26 is modernized. I'm not sure anyone knows what the hall refers to, but pretty clearly the sergeant is responsible for ensuring proper ventilation and temperature control in Senate spaces. So that's just modernizing that language a little bit.
Senator Drazkowski.
Thank you, Madam Chair. And Mr. Bodden and members, I read the part on telephones, and I think maybe now might be the time as we go through this process, Madam Chair, to just think about telephones and long distance. I got rid of the phone in my office as soon as I arrived. Every member, I think, uses a cell phone. I think my opinion is none of the members really need a phone in their office. Maybe their LAs do. Some things for us to think about is, since we're talking about telephones, probably not a need to have long-distance fees or charges be part of it. Maybe we want to remove that from our practice. Anyway, that's my thoughts, Madam Chair. Thanks.
Thank you, Senator Drazkowski. Senator Rest.
Thank you, Madam Chair and Mr. Bodden and Senator Drazkowski. I agree. Here's another opportunity to modernize and bring, what's a telephone? I mean, and many of us don't have telephones at home either. And so it's an outdated technology that we could change and have, and not have to revisit it if we talk about, some sort of technology communication thing. Or we just delete it because it doesn't work. I mean, we don't do it.
Mr. Bell is quaking just a bit. I can feel it. Secretary
So,
Bodden.
Madam Chair, and Senators Rest and Drazkowski. What I will say about this one is that there was an appropriation made in the state government bill last year for changes to the voice over internet protocol system. That funding was provided. A group of staff from the LCC, the Senate, and the House have been working on what is necessary to accomplish those changes. And while the work is certainly not complete, I think you'll see very significant changes coming in that area, and certainly would add, I think Senator Drazkowski said this, it's very important that legislative assistants have a phone number for members of the public to call and others to be able to contact legislators. The need for things like telephones in the chamber desks, et cetera, that's all under consideration.
Thank you.
Please proceed.
Thank you, Madam Chair, and I promise to do my part to keep this moving fairly quickly. Changes in Rule 54 are shown on page 26. Again, there's some posting requirements that are modernized. I'll draw your attention to lines 26.7 and 26.8. There's language here that really is superfluous. It simply states what any member would have the right to do, which is to prepare a resolution and submit it for adoption by the Senate relating to an action of the Rules Committee. We're not really sure where the language came from and do not see anything, any additional power or authority it would provide beyond what a member already has. Line 26.17 contains a change intended to reflect that I think were this language read literally, no change in the assignment of duties to an employee could be made without having the Rules Committee approve that. I don't think that's what's intended or needed any longer. Very clearly, the Rules Committee does have the authority to direct and really provide final direction on matters like salary, ranges, things like that. Moving ahead to Rule 55, these are just conforming changes, again, grouped to caucus, as it appears in Rule 55, I think. That completes the proposal. The remaining changes are all technical and conforming and have been described previously.
With that, Secretary Bodden, thank you.
Thank you.
Very much for the work, and members for the questions, knowing there will be more in between. We appreciate your time and your work. Members, we are gonna operate now knowing that I have a list of some proposals, but I don't have a list of all proposals. So if you are here with a proposal that I don't call, but it is in the category of what we're talking about, please raise up your hand and say, I've got something to add in this discussion. And we're going to begin first with 54.1, which is being brought by Senator Champion. Please welcome to the committee. 54.1 is being distributed right now to members. And Senator Champion, if you'd like to begin, it's good to see you.
Thank you so very much. Thank you, Madam Chair, and to the committee for allowing me to speak today and put forth a proposal for your consideration. I recognize that there's no action that's going to be done today. This is put forth as an opportunity for you to think about it, and then when we come back, or even between now and when we come back, if you have any thoughts, we'll certainly entertain those as well. The proposal that I'm putting forth today is really about the Subcommittee on Ethical Conduct. That is a committee that I currently chair. So I want to go through a couple recommended changes and answer any questions that you have. If you look at line 1.16, that you'll see that it strikes shall investigate, and just that we have there that a member may submit a complaint in writing and under oath to the chair of the subcommittee. That just makes it a little straightforward and really clear that any complaint must be put forth in writing and under oath and submitted. You also see on line 1.20 that the chair of the subcommittee must promptly provide the subject of the complaint and members of the subcommittee a copy of the complaint. And complaints and any information included with or attached to the complaint are public after being provided to the subject of the complaint and members of the subcommittee. That just, just, if you clearly think about it, that written complaint is submitted, the chair has to make sure it's distributed to the subject as well as to other community members, committee members, and also just to make sure that everyone is clear that any and all information that is attached and provided is public. And at the end, when I go through this, I also will ask counsel if I got everything right, so that she can let us know. Then if you look at line 2.1, it just simply says that the subcommittee shall investigate a complaint that satisfies the requirements of 55.3. That's all that is. And then you just see some conforming changes as far as numbers. But if you go to line 2.12, this is a substantive change. From this vantage point, the subcommittee must not call witnesses or take testimony during an executive session. An executive session must not be recorded except upon a vote of 3 members. A recording must not be made available to the public until the complaint has been finally acted upon. Just so that you have some context, what can happen is when the subcommittee meets, they talk, there's testimony that's presented, each side is given ample time to make their presentation and for the committee to ask any questions. And then what happens is that they can ask for, a member can say, hey, or the chair says, let's go into executive committee. And then that's usually done in a different room where the parties get an opportunity, or not the parties, where the committee members only get an opportunity to talk about what they see and try to figure out what should or could be the next step. Right now, just for your clarity, no witnesses go in there. It's not an off-the-record discussion where witnesses are talked to. It's just for the members alone. That tape currently it's recorded, so that becomes available for the public or anyone, sometime after that. Under this proposal, it will still be available, but it will be available after the complaint has been finally acted upon. But that would be the change there.
Senator Champion, can you pause for a question?
Can I pause?
Yeah, for a question.
Yes.
Senator Rest.
Thank you. If a person, well, either person, either the complainant or the person being complained about, so objects to what happened in a meeting of the subcommittee, does that mean that, and there's no recording, and they bring litigation against the Senate, is the discussion within the subcommittee privileged, and as it would be if you were talking to your attorney, and not subject to public disclosure? Is this making whatever happens in a subcommittee meeting privileged?
Senator Champion.
Madam Chair, Senator Rest, it doesn't make it privileged. The best analogy that I'll give for you that I can think of is sort of equivalent to when there's a chamber conversation between attorneys and a judge. That's private. And the only time that is revealed, obviously, they go out and put it on the record. They say, hey, we had a chamber meeting, and here's what we talked about, or here's what was concluded in that meeting. The recording can still be done if 3 members of the committee says, hey, I wanted to be recorded. So that's where you see in that line that says, an executive session must not, is line 2.13. An executive session must not be recorded except upon a vote of 3 members. So 3 members can raise their hand and say, hey, I want it recorded, and it will be recorded. And the reason why we came up with 3 is because of the fact that you usually have 4 members, and so you want to make sure that you have representation from both sides.
And
Senator
Madam-
Rest.
Thank you, and Madam Chair. So it can be recorded with the request of 3 members, but it's still not available to the public until as you say, until the complaint has been finally acted upon. And at that point, that recording, if it happened, can be made available to the public and used by either the complainant or the defendant, if you will, in any further action, either against the Senate.
Senator
Madam
Champion.
Chair and Senator Rest, I'm not sure if I would say it would be used against the Senate, because traditionally now, those recordings are not used against the Senate, because this is an ethical complaint that's been brought against a person, right? So it's really just making sure our members are functioning in a way that doesn't bring disrespect on the body. So I wouldn't use the word against the Senate in some other legal context.
Okay.
Senator Pratt.
Excuse me. Thank you, Madam Chair. Senator Champion, I'm curious why we would presume that the executive session is not recorded versus the presumption that the executive session would be recorded unless there's 3 votes. And I'm thinking back to other bodies that I've served on where when we go into executive session, we recorded those deliberations for, like you say, after the case has been resolved. So can you touch on that?
Madam Chair
Champion.
and Senator Pratt, right now, that's the way it is right now. Right now is, you go into executive session, it gets recorded, it doesn't become available until later. But what I've gathered in my experience, even with then Senator Osmic with us being chair, what happens is that individuals, we would go into an executive session and then we go in the hallway, right? Because of the fact that people sometimes want to have a private discussion to kind of push each other or bring some clarity. What I was trying to create was just an opportunity for the body to be able to have those sort of forthright discussions with each other, and then figure out what should or should not happen, that you eventually have to go back on the record in order to talk about. But if that's something that this body doesn't want and want us to keep it just the way we have it, we can certainly do that. But I just thought it always, creates a little more forthrightness amongst people when they can have their own private discussions that doesn't challenge transparency or accountability or anything of that nature.
Thank you, Senator Champion. Please proceed.
Thank you so much. And Madam Chair, if you look at line 2.27, we just struck that language there because we wanted to provide some clarities in another place in the proposal. One of the things that was constantly challenging is if you look at line 2.30, is that we never would know what happens with a complaint, if the committee reaches an impasse and it just sits out there. Sorry about that. The matter just sits out there forever until we, break, sine die. And so we tried to address that. If you look at line 2.30, we say, if a vote to find probable cause, so that's one thing, and a vote to proceed with an investigation have both resulted in a tie vote and the subcommittee is otherwise unable to proceed, because we're at this impasse, the complaint is deemed to be dismissed 30 days after the final meeting of the subcommittee unless the subcommittee meets to take further action. And the reason why we put it that way is we know that, let's say there's an impasse, 2 and 2, nobody's moving, then it just sits there. But let's say within that 30 days, we get some additional information that would help, then there's still an opportunity for that additional information to come forward, and then for the body to take action in a way they deem appropriate as a result of that additional information. And we also have here that the chair of the subcommittee must notify the complaint and the subject of the complaint when the complaint is dismissed pursuant to this rule. So if it's just laying dormant, nothing's happening, no new information has been brought forward, then it will be dismissed, and the chair has to notify everyone that the case is dismissed. Otherwise, it's just in purgatory as it is right now, that nothing happens.
Senator Drazkowski.
Thank you, Madam Chair. Thank you, Senator Champion. I really don't want to get into debate on it, but just to point out that doing this places a lot of power in the chair of the committee or of the subcommittee, because they're the ones that will decide whether or not to call the next meeting or whether there will be one. Anyway, that's all I have, Madam Chair.
Senator Champion.
Madam Chair and Senator Drazkowski, not really, because the power is really in the hands of the committee, right? And if there's an impasse and there's nothing that's going to happen because they've already spoken, a case right now just sits there and nothing happens to it. It just sits there forever. But that's also been unnerving for others who have been the subject of a complaint, because it just sits there, and the committee also finds it a little unnerving because it's like, what do you do? There is nothing. So I would hope that you would think about that a little more, but it's not in the power of the chair deciding when they should dismiss or not. If there's new information, it goes to the body, because as I mentioned earlier, if there's a complaint or there's a submitted documentation, there's a requirement for it to be disseminated immediately to the committee.
Senator Drazkowski.
Thank you, Madam Chair. And Senator Champion, I will think about that. If you will think about who is it that calls a meeting and decides whether or not there's a need for the next meeting.
Absolutely. Oh, sorry, Madam
No.
Chair.
No worries,
Senator
Senator
Drazkowski, absolutely. All right. So if we would go on to the next page, if you look at line 3.9, we just wanted to clarify a couple of things. Like, for example, sometimes when a complaint comes forward and against a person, and then the person says, hey, so is the Senate going to provide me legal counsel? And the answer to that is no. And we wanted to make that clear under this rule. So if you look at 3.9, the Senate will not provide legal counsel or reimbursement for legal counsel for any party to a complaint. The complainant or the subject of the complaint may be represented by counsel at a hearing of the subcommittee. A person has the right to have counsel represent them if that's what they want to do. If you also look at lines 3.12 all the way to 3.18, it just says, we needed a process, just before I read it, we needed a process for sometimes a complaint is submitted in writing, and then a person, after they talk or whatever happens, and they want to dismiss the complaint. Right now, we're like, okay, how do we really do that in a real way, right? So what we are proposing, as you see here, is that a complainant may withdraw the complaint by submitting a notice of withdrawal in writing to the chair of the subcommittee. If the complaint was brought by multiple complainants, a withdrawal by one complainant has the effect of removing the complainant's name from the complaint, but does not withdraw the complaint in its entirety. If a complaint is withdrawn by all complainants who submitted the complaint is dismissed, and the chair of the subcommittee must notify the subject of the complaint. Notices of withdrawal are public after being provided to the subject of the complaint and members of the subcommittee. So we just needed something. What if somebody wants to withdraw it? How should that occur? And we wanted to also provide some guidance for if there's more than one person on the complaint that says, it's me, Joe, Robert, or whoever, right? So if just one of us dismiss the complaint, it's only dismissing their name off the complaint. But if all agree and all want to have it dismissed, then it would be dismissed under those circumstances. So let's see, that would be it. And Madam Chair, if you don't mind me just at least asking counsel if there's anything else that I should have highlighted or failed to mention, because she is a great mind. So I just want to see if there's anything.
Ms. Stengel.
Madam Chair, I have nothing to add. Thank you.
Thank you, Ms. Stengel. Senator Dibble.
Thank you, Madam Chair. Senator Champion, with apologies, if we could just backtrack a little bit.
That's okay.
You know, you get your ideas when you get your ideas, I guess. So I was just looking at the elimination of Rule 55.7 on line 2.27 to 2.29. I might have missed it when you explained the reason for that deletion. So if you could either re-explain or if I could just ask, are we presuming that special counsel, when we refer to special counsel, we're not referring to the illustrious Ms. Stengel, we're talking about outside counsel in this instance, and that is something we don't want to do? Or maybe I just missed the whole thing. Thanks.
Senator
Madam Chair,
Champion.
thank you, Senator Dibble, for that question. Really, what we're trying to clarify is that the subcommittee may appoint special counsel to provide expert advice on how to conduct its proceedings. We wanted to be clear that there was not going to be any special counsel, that we have our in-house counsel and others like Ms. Spangle and others that will guide us around the investigation or answer any questions. That just was confusing to have special counsel mentioned in the rules. That's my understanding.
Senator Dibble.
Thank you. So great, that helps. So that does not preclude the great advice and guidance that we would get from Ms. Stengel. Thank
Ms.
you.
Stengel.
Thank you, Madam Chair and Senator Champion and Senator Dibble. That's correct. You still have my services for the committee, and the Senate and the chair of the subcommittee also has the authority inherent as the chair and inherent as the Senate contract with outside counsel if you felt the need. This particular provision hasn't really ever been used, and it's seen perhaps as a way to delegate away the authority of the subcommittee in a way. So if the committee so choose, they could still hire an outside body without this rule, or an outside person, not an outside body.
Thank you, Ms. Stengel. Senator Rest.
Thank you. When we heard the Secretary's recommendations, if you look at 55.1, the Secretary's recommendations included removing the words group and putting in caucus. And I think we're going to find that there are overlapping amendments where that language comes in. And I think it may be just of interest to indicate when people like yourself are recommending changes that you say, I endorse the change made by the secretary with regard to deleting group and using the word caucus to be applied in your amendment too. And we might at some point just direct staff that any place that happens that comes up in an individual member's one, that we take the recommendation for changing group to caucus in kind of an automatic instruction when we're going forward, rather than a member having to look through their own suggestion and making the corrections as they go along. So just a thought in terms of procedure and editing down the line.
Thank you, Senator Rest. Ms. Stengel.
Thank you, Madam Chair. And Senator Rest, you read my mind. As I was going through and drafting these, instead of making all of the shalls to musts and those individual changes in each of the bill, I knew that the proposal from Mr. Bonner picked up all of those changes. So the subcommittee can decide what to do, and instead of doing all of them throughout, the subcommittee can just instruct at the end what the preference is, and I can put those all together.
And Madam Chair, it would seem
Senator
to me
Rest.
that some of the basic changes, if we adopt them first to be part of our report, that we don't have to quibble about where that language comes up anywhere else. It will just be understood, and a member won't have to, again, go back and make all those changes themselves when they're making an official, when we're voting on something, they won't have to do that just for efficiency.
Thank you, Senator Rest. Senator Dibble.
Manager, my matter is very small. I'll just take it up with Ms. Stengel or Senator Champion privately. Thanks.
Thank you, Senator Dibble. Seeing no further questions, Senator Champion, enjoy the sunny afternoon.
Oh, thank you
for
so
your good
very
work.
much. And thank you for thinking about this proposal. Appreciate it.
Next before us is SR 056, and this is coming from Senator Bolden. Welcome to the subcommittee, Senator Bolden. Please proceed.
Thank you, Madam Chair and members. So I will preface my comments with acknowledgement that this, obviously would be a change that people likely have strong feelings about on both sides, and so present it as a proposal for, discussion and consideration. So this rule would provide for a pre-filing deadline for amendments for both committees and on the Senate floor. And just to say a few words about my thoughts about the rationale for that. Clearly, the work we do carries a lot of gravity. There are big consequences to the decisions that we make. And so I think it is important to be deliberative and thoughtful and intentional, and that having this process would allow for more of that. It would be a clear, transparent process, and would allow for, I think, more thoughtful discussion and work in both committees and on the floor. I have experienced myself and have seen this many times where an amendment is brought and the author will say, I'm just seeing this now. It's a lot of information. I'm not really sure, what the implications might be. And so, the work either, that impacts the amendment itself and the work that happens after that. And so having those amendments pre-filed 24 hours before would allow the author to gather information, to think through those implications, to talk with counsel, to talk with stakeholders, to talk with the author of the amendment, and allow for a more, I believe, productive process and a stronger outcome. Another piece of this I would mention, while is certainly not the primary driver, but not without consequence, is the impact this would have on staff and allowing them to not be scrambling at the last moment, but would allow for more time and, to do the work of handling those materials and bringing things together. I also will recognize, so maybe I'll just walk through a little bit. The first sections talk about pre-filing for floor amendments, and it talks about a process that is connected to the process that would be of when bills are posted, that they, will be taken up. And in conversation with counsel, when drafting this rule, there was recognition that it as was mentioned before by Senator Rest, there's interplay with this and some of the other rule changes. I think that Secretary Bodden brought earlier, so there's sort of maybe room for some changes on the specifics of the mechanics based on, how other rule changes might happen. But essentially, based on the posting of the bills that would be heard, prior to that, then would be the pre-filing deadline, 11 a.m., 24 hours before. And then the second section is about committee amendments, and then realizing that there may be cases where it is appropriate and necessary and valuable to do things more at the last minute, allowing for a process for that, creating a subcommittee of members to make those decisions when it would be appropriate or when it is requested and could be designated. So with that, Madam Chair, happy to take questions if there are any.
Senator Pratt?
Thank you, Madam Chair, and I don't know that I have too many questions reading through this right now. I think more concern than anything else. now in my, I think, 12th session, and having the opportunity to serve in both the minority and majority, I understand how ideas tend to flow. That during debate, and we want free-flowing debate, as Senator Dibble just said, you get a moment of inspiration that hits you at a time. And we've always had the ability to, as Senator Bolden said, if an author wants to consult with stakeholders, we can always lay a bill on the table. I've had several instances where we've not taken up an amendment, but agreed to work in concert before getting maybe to the next stop. And so this to me seems a bit unnecessary, given how the Senate has operated in the past. And I'll even use yesterday as an example in finance, where, I had an amendment drafted and I chose not to present it based on the discussion, the deliberation that we had. So I think it goes both ways. And I think it'll end up putting a greater burden on our staff if we are expected to think through every amendment without taking the deliberation into part of that decision-making. I'm losing my words right here, but I just wanted to at least put the concerns on the table from both, again, being fortunate enough to have the perspective of being on both sides of the debate.
Senator Rest.
Madam Chair, I appreciate the brevity of Senator Bratt's concern, but just to be reminded once again, we're having the presentation of ideas and questions, and we're not debating them about whether they're good or bad or whatever. Otherwise, we're going to be here a much longer time than is necessary. So, thank you.
Thank you, Senator Rest. Further questions? Thank you, Senator Bolden. The next that we have is also a Bolden proposal. And this is going to be handed out right now, dealing with remote testimony, I understand. So this is this SR 043. Senator Bolden, if you'd like to proceed.
Thank you, Madam Chair and members. This proposal would require all committees to allow for remote testimony from the public. Having that testimony and input from the public is very important and valuable in our committee process. And given the geography of our state, depending on where people live in the state, it can be a burden and a difficult thing to travel to St. Paul to provide what may be 2 minutes of testimony. There's issues of getting off work and childcare and expense of travel and weather and lots of factors that could be barriers for people to get here to give valuable testimony to us. And so given that we have the technology to be able to do this, this proposal would just say that all committees would need to allow for that remote testimony from the public.
Senator Rest.
Thank you, Madam Chair. I believe the practice on some committees now is to allow remote testimony of anyone who is not a lobbyist, and that or at least in my committee, we don't allow lobbyists to testify remotely, so they cannot be in Las Vegas gambling away and from their hotel room think that they're doing their job by testifying remotely. So I might suggest the permission for remote testifying, but with a carve-out that wouldn't be allowed to, ask you to consider that it wouldn't be allowed to lobbyists, which is the practice in I think, well, in my committee, but maybe in others as well. Not advocates or individuals, but you can even say compensated lobbyists or something. But that is, I'm not debating it, I'm making a suggestion. Thank you.
Senator Pratt.
Thank you, Madam Chair. While I appreciate the brevity of Senator Rest's comments, I would like to hope that we could keep it to questions and not debate.
Well, I wasn't debating, I was making a suggestion.
Oh, eyes of the beholder.
You
Thank
think-
you.
You think it was, okay, sorry.
Further questions for Senator Bolden? All right, Senator Bolden, enjoy the sunny afternoon. Drive
Thank you,
safely home.
Madam Chair.
Next on my list, Senator Marty, and this is SR 035.
Thank you, Madam Chair, members of the committee. Senate Rule 35 would be proposing to change it so that we would allow members who are participating in the process to fully participate, even when they're remote. In other words, it would make it that we could have divisions in which we count the members' vote. We did this already during COVID, early in the COVID process. We were all in separate rooms, and a division was called, and we'd all go around, and how many, you got 3 here and 2 against, and each room would do that and so on. So we've done that before, and I think some committees have allowed, I think it's not spelled out very clearly, but some committees have been using divisions where they include people who are remote and so on, and some on the floor. I think that one of the things it would help avoid surprising somebody. In other words, we've got a thing that might be, you clearly know you have the votes for it, but I don't want to bother to call a roll call because it's not a big deal. And therefore, if there's a division and there are a lot of people who are remote and so on, you know you've got the votes, so you ask for roll call and you get it, but it seems to be slowing down the process for things like that. I just think it makes more sense to have, if I'm participating in the process, if I'm listening to the debate and doing that, that I should be able to be counted remotely. So anyhow, that's the extent of that amendment proposal.
Questions? Thank you, Senator Marty. I appreciate that. Next, I believe, is a Rust proposal. It would be, I believe it's Senate Rule 034.
May I sit here?
All right.
Thank you.
Just for today because it's a subcommittee.
This is to Rule 40.9, and this was a floor amendment before for the temporary rules to not allow members who are voting remotely to accept per diem on a day when the member voted remotely. We allow just some settings on this. If it's on a day when you're in committee, but we don't have a floor session and you're voting remotely, you're allowed per diem. It's only on a floor session when you're not. And I think this presents a hardship, particularly because of the number of members we have who are women, that we have, sometimes they have to be home, but they have small children, they can certainly participate and are watching and so forth, and we have a system where they can participate in voting remotely. They have a system where they can participate remotely in a committee, even if they're unable to be on the floor, and that we should just delete that rule. And I do think that I had thought about, well, how about this scenario, or how about that scenario? And it ended up being one of those rules where we have otherwise rules like this. It has a lot of hairy arms. That, well, under this some circumstance you can, and under this you can't, and so forth. And I think we need to be respectful of the times when members, according to the policies set by respective caucus leaders, which is not being proposed to be changed here, our leader, the DFL leader, sent out a memo to our members because she has the authority to grant remote participation to our members. Whether the Republican leader did that or not is none of our business. They have their own rules, and they should be able to follow them without the approval of the DFL caucus. And it seems, and she has laid out certain circumstances under which she will approve voting remotely, and some of them do include, as you might expect, illness of yourself or illness of a child, a death in the family, even a happy occasion like a wedding. But you could still participate, and it seems to me that we should honor that, and that allowing per diem is a family-friendly thing that doesn't say, no, you'll have to hire somebody to come and take care of your sick kid, because if you, many people, many members rely on the salary supplement of the per diem, and if they have to miss 3 or 4 days, that's a few $100s. And so I will hope that when we come to vote on these amendments to the rules, that we take all of those points into consideration and delete this rule. And I could talk about it a whole lot longer and give examples, but I think each of us can come up with them in our own minds for when we ended up not being able to vote remotely, even though we were, we had to vote remotely. For myself, it's any number of days when I was in my office in the building. But because I was working on the tax bill, did not come down to vote on the floor, and because of that, lost per diem. It was worth it, but I shouldn't have been asked to do that, nor anyone else. And so I hope that we will abandon that rule. Thank you very much.
Thank you, Senator Rest. The next proposal before us then is SR 037. This is another Rest proposal.
I wonder what this one is.
Thank you.
Madam Chair and members, Rule 17 ended up last year being an amendment with a lot of hairy arms, and we have, and what I've tried to do with the rules under decorum is to simplify and actually separate provisions that were all gathered in one. So you will, it used to, we would say that I separated into, starting with 17.5, that demonstrations, and that this usually is under the authority to call to our attention that demonstrations are prohibited in the Senate chamber and the galleries at all times. You can see that then that word is stricken in 17.6. And in that rule, separating it and then saying at all times food or beverages are prohibited in the Senate chamber and the galleries. And last year, we had the water rule, and we started adding all kinds of things to it, which to my mind, and by the way, I support the rule, led to absurdities. So it seems to me you either have water or you don't have water. So the notion that you can only have it when floor proceedings are expected to last more than 1 hour is silly. It's just plain silly. And we should just allow it or not allow it. And this rule says it's allowed. And then the other thing that we neglected to do, again, because we had an imperfect process on the Senate floor, is we gave ourselves permission, but we're not the only people in that chamber that are there for the whole time. So is a number of staff people. So this rule change says that both the Senate, members of the Senate and Senate staff have the same privilege or right, and all they have to do is, when it's not being consumed, find a way to store it out of sight. Yeah, and for members can keep it in a bag. They can keep it under their desk. A staff member can do the same thing or find some place to store it, and perhaps the secretary can, give some suggestions about how this rule would be applied, but we don't need it in the language of the bill, just that it's out of sight. And quite frankly, I've been very pleased myself that that actually has happened pretty normally. You don't see members sitting at their desks, like I am right now, because it is allowed in a committee, with their water bottle on their desk throughout. They take a swallow and they put it away. And that culture now has developed there that doesn't happen. Seems to me we should indicate that in the rules, and we don't have to have it in a sealed, unadorned. I mean, what does that mean? But a sealed container. Why do we still want to keep the word sealed? And that is because when you're not drinking, you can have a tendency, like I'm struggling with right here, of knocking the bottle over and spilling it on the desk. And those are cast over desks, and it's really fine carpeting, and it's up to us to be good about that. And that means, like I tried to do a couple of weeks ago, I had a cup of water, and Mr. Lynn said, sorry, and this was not when we were in session. This was after. He said, you can't come in here with that. And I thought, good point. I shouldn't. I should have this. If I want to sit in the chamber and work, I should have water in a sealed container, not flopping around in a paper cup. And so I think this acknowledges the appropriateness of members that wanted this rule change, including our majority leader, and it extends it to staff. It simplifies it, and it is an acknowledgement that it's appropriate from someone who fought it for years. I'm now a supporter, and I would like the rule changed in this manner. Thank you very much, Madam Chair.
Senator Drazkowski.
Thank you, Madam Chair. I'm going to keep my remarks really short because I want to save my debate for next time, and that's what we're going to do, right? Okay, so I'm just, Senator Rest, I really like the demonstrations part, and you did a great job in tax committee at chasing the demonstrators out. And I'm wondering if we should.
I just asked them to leave. I didn't ask them, I didn't chase them.
Well, I characterize it as that, Madam Chair. Could we add that to, could we add committees to this too? Something to think about. I don't, maybe we don't need to discuss it real long. I know we got a bunch ahead of us, but I'd suggest maybe considering adding committees to the demonstration portion.
Thank you. Senator Drazkowski. Senator Dibble.
Thank you, Madam Chair. I'm going to pre-file an amendment to the water amendment to say that we can also have peanut M&Ms in the chamber. I'm just kidding. I said I'm going to amend your water amendment to say that we can also have peanut M&Ms in the chamber.
Peanuts and M&Ms?
I'm just kidding.
Senator Rest.
Yes.
All right.
That's in my.
Senator Rest's favorite candy.
Thank you. Further questions? All right. Next, SR 066. This is a Marty proposal.
Thank you, Madam Chair, members of the committee. This one is one that probably could or should have been in the modern list of technical things, but it was a little late for that. And this is one that fiscal staff suggested just to make the rules clearer and more readable. We're simply making the sentence more understandable. It's the same words, I think, and I'd urge your support. And it's simply for when the budget targets are announced, it doesn't change any of the substance of it, just the order of the sentence.
Senator Rest.
Madam Chair and Senator Marty, that's not done by that's not done now? Or is this just reordering?
Madam Chair, Senator
Senator
Rest,
Marty.
this is purely technical amendment. We're not changing any of the substance. We're just starting with the last half of the sentence and ending with the first half of the sentence because it's much more readable this way.
Thank you.
Senator Pratt.
Thank you, Madam Chair. Senator Marty, just a question and maybe a thought. Since we tend to have supplementary budget proposals in even-numbered years, would it make sense to strike the odd-number year designation and if there is no budget target to be set, then the committee chair and the rules chair then say there is no supplemental target? Just a thought and a question to consider.
Yeah, thank you, Madam Chair,
Senator
Senator Pratt. I guess that's the issue, because we don't always have targets with them and so on, and there's debate whether you should have targets or not. I think we could keep discussing. I kind of feel that, that in a case like this, that some years you're going to have them, some years you're not. So I don't know. It seems to me the rule is for when you have we have to have them for the budget cycle, and so we could discuss the other one more, but this was meant purely as a technical thing.
All right. Seeing no further questions, thank you, Senator Marty. Next is Senate Rule 031, which is also a Marty proposal.
Okay, thank you, Madam Chair, members. This one take a little more explanation, and the point of this is one that would set time for floor debate in the Senate. And I have two purposes for doing this, one of which is not to limit debate, but to improve debate. And the second is to be more humane and responsible in how we legislate to staff and members and the public. And that is that everywhere we have times for things. We have committee times. If something's going to go too long or something, we can make different plans. But with floor debates, I've noticed it's getting worse for many, many years. And this would be simply saying, instead of saying, members, there have been all kinds of proposals, you can only speak once on an issue. Well, what happens if you make a point and somebody else makes other point, rebuttal point, something else? It seems to me that capping you at one presentation on a bill or an amendment may be not the most helpful to a debate. But here we often have debates that aren't more whatever, more thoughtful because they go more hours. And this was a proposal that would have a small subcommittee consisting of the majority and minority leaders and the Senate president that would come and set time limits for debate on bills. And in order to protect the minority rights, make sure that, excuse me, all of the limits would give at least half the time to the minority. So because the majority, in effect, could say, hey, we want to limit it this long. Majority usually is the one presenting the bills, and that time goes against their time and so on. But it would be a 50-50 time, and it would be simple, non-debatable motion to extend debate. If the minority felt they did not get their majority, their 50% of the time, by a simple request of the minority leader, it would be extended. And again, the simple majority of those there could extend it, and it would be simply enforceable by in effect, point of order. I'm open to any other way of doing it, but it seems rather than have the president and the front desk have to be timing this, if debate was set for 4 hours on a bill, and it's 4 hours and 10 minutes into the bill, somebody said, Madam President, we've gone past the debate time. The president would have their ability to, Senator, I think the debate's wrapping up. It's a good debate. How about we then urge the members to move a little bit to wrap it up quickly, but they wouldn't have to rule on it. And if that was the case, then anybody could move to extend debate. But the benefit of this, among other things, I think was shown the last week of the last session. We were having very many, very lengthy debates, and the majority and minority leader negotiated time limits. I had urged at the time, majority leader to consider something like this, and she said, let's try it for this week instead of going through rule exchange and so on, to consider a voluntary thing. And the majority and minority leader negotiated time limits for every bill for the last week. Some were, I don't know if it was 5 hours for the tax bill and 4 hours for human services, but every one of those bills they set a time limit on. Every one of those bills, the debate ended probably an hour or more before the time limit ran out. And what that suggested to me is what happens then is if you know there's going to be 2 hours or a half hour for a minor bill, the minority leader and majority leader, oh, hey, we get no more than 15 minutes guaranteed here. You get your best speakers to get prepared to go first and so on. And if there are more things to be said, I mean, when there's a really controversial issue, sometimes every member wants to say something just so they're on the record on the floor. That's fine. Some debates should be longer, but we often have things where it's a bill that, how long is this going to take? 15 minutes or 5 hours? And one of the problems we have then is we're meeting 2 in the morning. And that's, I think, one that's offensive to the public who figures people can't think straight when they're very tired and you're trying to write laws for the state at 3 in the morning. And the other problem is a lot of members have family obligations, childcare they have to take care of. And when they go in there not having a clue how long it's going to be, it seems to me that this is a responsible way, and again, I'm very sensitive to the fact that it could be unfair to the minority, which is the reason for putting in the thing, that simple request by minority leaders saying we haven't had our share of the time, and guaranteeing at least 50% of the time to the minority. If the majority says, hey, these bills take half an hour to explain, well, then set longer time limits. And it's in effect a negotiation. You could do it for a type of bill in general, or you could do it specifically for specific bills. And the other point I'll make about the experiment the last week of the last year of session, I think the debates were much better then. Not just were they, frankly, shorter, but people were saying things that related to the bill and wanted to be said. And I don't want to cut off any of that, but I think what we've had now is frankly abusive to some of the staff or members or others who have to be there when they have no idea. I mean, most jobs you have a sense what time you might be going home from work. And some of our Senate council staff and so on, well, they're going to be out of here at 6 in the evening or 6 in the morning, and there's no clue until then. That's the point of it. I'm happy to take questions on it and happy to discuss other ways of dealing with it, but I think this is a rational way. I took a look at what our House had done. I looked at, from NCSL, what other states have done to try and manage this, and it's an attempt to manage it in a responsible way, the same way a committee has basically time limits, and yes, you can extend them if you need. You can extend and meet the next day if you need. But I think the one exception to our process where we have an orderly process that's designed to reflect respect the rights of the minority to speak and everything else, but also to have management of time so that we don't waste, I would argue, sometimes inordinate amounts of times on minor bills, which then takes away. The biggest argument I had against trying to separate more bills out and having less omnibus bills was that we don't have the floor time. And I think this would help manage it so we could have more important bills debated longer and everything else. That's the gist of that, and I'm happy to take questions or talk with members individually after this.
Senator Rest.
Thank you, Madam Chair. Just trying to get clear in my mind. You've numbered or included now your suggestion for Rule 5 and 6, but adding Rule 5, that they are not debatable. But then I just want to make sure I understand that Rule 1, or the question, et cetera, number 1 there, a motion for adjournment, and we had this in the Secretary's presentation about the circumstances for adjournment, and I believe we are allowed to amend it. But you are picking out just one of these 10 to say it's not amendable. Is that correct? Some are not debatable, but they are amendable.
Yeah, Madam.
Is that not correct?
Madam Chair,
Senator
Senator
Martin.
Rest, I wasn't envisioning this being something amendable. I don't think we want to have it debatable, otherwise you'll spend all the time debating
Yes,
how
I
long you
understand.
go. I've seen that happen in places. But in terms of that, it seems to me that if the author of the bill or minority lead on the bill or anybody says, you know, hey, this is a really important debate, can we extend it? I'll suggest a half hour, a 30-minute extension or an hour extension. It seems to me that if at that point somebody can just say, no, we need more time, or we don't need that much time or something, informally, if you do that, I propose we extend debate for an hour. And you come over to me, John, we don't need that much time. Then, excuse me, I'll withdraw that and make the motion to be extended for a half hour. In other words, I hadn't envisioned people doing it formally where we'd amend it, but I'd be open either way. The point is we don't want to spend our time debating the time.
Yep.
Senator Rest.
Thank you, Madam Chair, and Senator Marty. I would just request that you look through this list of 10 when you're looking at ones that are included as not debatable, and then ones that are amendable, so that they don't end up being at cross purposes with one another, and that they're just clear when you're, later on, maybe when you're going to be asked about them.
Madam Chair,
Senator-
Senator Rest.
Senator Marty.
The language on 2.4, the like 28.5, a motion to extend debate is not amendable. That's not the gist of this, because I think it'd be kind of an informal thing anyway, but the point is to have it where we focus on the good things. So thanks.
Seeing no further questions.
Madam Chair.
Senator Marty.
After that one, I just wanted to make one brief comment, if you'll give me permission, about one of the rule changes, the technical rule changes, just to make a comment on it, and I talked with Secretary Bodden about this, and that is the decision to eliminate the general orders from the rules. I think his point, it is a technical thing because we haven't been using it, and it's a huge page of the rules that's confusing new members. What's general orders, what's this, and why is that all in here? Why do we have a general orders calendar that's handed out every day and everything else? And just to say that I realize we don't use it, and I understand therefore why I remove it from there, but I also want to say that I think it was a more accountable way of doing it. I think it actually fit more with the spirit of the Constitution, which says bills should be read on 3 separate days. And we used to, I mean, technically, as the Secretary pointed out, the first reading, the bill introduction, it's read and introduced, sent to a committee, so the public and the legislators, everybody get to consider it. The second reading, which is technically when it's reported back, that was the general orders where we could amend it. We had good debates. We'd actually have, I remember many times, unlike in Washington, unlike here, now when somebody lean over somebody next says, how are you voting on this amendment? And I was going to vote against it, but so-and-so just said something that I'm kind of thinking this. We actually had real debates kind of thing, and I'm not expecting us to go back to that, but we then would have the calendar the next day. So if you put amendments on a bill, you wouldn't have the final vote till a day later unless we suspended the rules, because if there are a whole bunch of amendments that go on, maybe people want to reconsider. That was a bad amendment or something they may want to reconsider. So it was more deliberative. I think it was a better process. I'm not saying we're going to go back to that, but again, the Constitution allows an exception for that when there's an urgency, but we in effect are rolling things together, and everything being special ordered makes them not so special anymore. So I just want to comment on that. It doesn't change whether we should take it out of the rules or not, but just to say someday I hope we can maybe go back to, that was a practice we had in the past. It was more deliberative and more public, I would argue.
Thank you, Senator Marty.
Thanks for your time on all
You're
this.
welcome. Enjoy the sunny afternoon.
Thanks.
That exhausts what I know of amendments coming forward, but I know there could be others. So are there other members present that have proposals that they'd like to bring forward? Senator Drazkowski.
Thank you, Madam Chair. I've got SR 51, if staff have that one available.
SR 51.
I can start talking about while it's getting handed around, Madam Chair, would that be?
That'd be great,
expeditious?
Senator Drazkowski.
Okay.
Thank you.
Thank you. So this is an amendment to end proxy voting, which is a process that we have been doing here in the Senate for the last year, which I think many of us believe is not constitutional. We did it in the way that we're doing it as a result of COVID and the response to COVID. COVID is over, and I did see proposals to strike out references to COVID in the rules already, and this would continue that. I'm not going to go through all of the elements of this one, but I've got some other ones that are somewhat similar, of kind of different approaches or varying approaches. But this would get rid of the remote voting and the proxy voting that's going on, because that's how we're doing it. We're having one member vote for another member, which is taking their election certificate into hand, if you will. Anyway, I don't want to get into debate because we've done enough of that already for now, and it's a sunny afternoon out. So that's the proposal, and
Thank you,
stand for
Senator.
questions.
Thank you, Senator Drazkowski. Members, do you have questions? We will move to contemplation then. Senator Drazkowski.
Thank you, Madam Chair. I also have an SR 59.
And Senator Drazkowski, if you have an order in which you want to take things, if you want to let us know,
Oh.
then perhaps the staff can
Okay.
get those together.
Yes. So SR 59, and then it'll be SR 40. And then I think we've got I think Senator Pratt and I have an SR 47 and SR 44. as there's an SR 69, and then I'd certainly like to address an SR 42. So I'll go through those again. 59, 40-1, then 47, then 44, then 69, and then 42.
So we'll hand them out as we are moving through, but that'll help
Okay.
expedite the process. And
Thank you. I got that in my file. Thank you.
when you're ready, Senator Drazkowski with SR 059.
Okay. I don't have it in front of me, Madam Chair, but I know that maybe it's here. Thank you. I'm wondering if staff would help, council would help remind us the difference between the first, this one, the first one I think included committees as well. So it included prohibition on remote voting and proxy voting in committees. And that was SR 51 that we just went through. This is SR 59, which would simply limit the prohibitions or the elimination of remote voting to the floor voting. And so, Madam Chair, that would be the difference between 51 and 59. And so this is 59, which would say we go back to the way that we have governed here under the Constitution. By the way, Madam Chair, our Constitution, and I don't want to get into too much debate, but just kind of as a foundation, says that the legislature shall meet at the seat of government. And then it goes on to say the seat of government is St. Paul, Minnesota. And so that is the spirit of which I am really driving these proposals so that we can continue to operate the Senate as has been operated for over 150 years. So that's SR 59. And then SR 40-1 is next. I've also got an SR 55. I apologize, Madam Chair, I've got a lot of papers.
No apology necessary. So 40-1, please.
We'll have them better refined by the next meeting for sure, Madam Chair.
So Senator Drazkowski, if you want to.
So SR 40-1, the description I have here is require member voting remotely to cast their vote via audio or video vote with the secretary and staff. So it would allow us to continue the ability for people for members to vote remotely, but would have an audio and video component that staff could use to capture the votes of people voting remotely. And that's what 40-1 does. 55-2 or SRO 55-2,
Let's get the 55 handed out, please.
which is inserted into our list by accident, but it's similar, Madam Chair, and that's
Okay.
why I'm introducing it now. This one is similar in that it says, and I'm just going to read the language for members here. The Secretary of the Senate, it's on line 3.10 of the 55-2 amendment. It says the Secretary of the Senate must implement a remote voting system that allows all members participating in debate as provided in Rule 27.11 and voting as provided in Rule 40.7 in a manner that allows all participants to hear one another speak. And I know there are other bodies in this country that of those that do things remotely, that's a very common thing. And that's it. Yeah, including the other body across the street. But, Madam Chair, you know, and again, I don't want to debate it right now because we've got a lot of material in front of us. But I just think it's responsible for us if we are going to have, again, these are maybe less desirable for me, but something that might be more desirable for other members. As we look at this, I think it's just responsible for us, to our constituents, and to the, you know, to members, and to debate, to use the technology that's available to us. If we can use a telephone, or if we can use the internet to allow, if we do remote voting, to allow remote voters to be more participatory, and to have the Senate be much more transparent than it is now. I know, and again, I'm not going to debate, but I know some members saw members last year, Madam Chair, that were either in the retiring room or on their way walking into the chamber when another member was reporting the vote to them, for them. And that seems problematic, and there's really no reason for us to be in that position. So that's that one, Madam Chair.
Thank you, Senator Drazkowski. Next on this would be SR 047.
Yes,
Madam Chair.
maybe Senator Pratt's got that one.
Madam Chair, I'll do SR 47. It follows along the same theme that Senator Drazkowski just addressed, putting some protocol around remote voting. This is modeled off of what the state of Montana is doing, where a member would sign a form and send it into the secretary, validating that this is how they voted. The next one would be SR 44.
Okay, we're just going to give the staff a moment to get caught up with us. Senator Rest.
Thank you. On 47, would you explain a little bit more how that would operate in terms of a remote, this remote voting form? Bit more details about that, if you don't mind.
Thank you, Senator Rust. And I haven't seen it in operation with Montana. How I would envision it is, say a member would have a form, they would type in the question being debated and their vote, and could email it or directly submit it to the secretary, depending on how we set it up. I think there's some leeway into the implementation. And that leeway is somewhat intentional, so that we can continue to find the best way to operationalize it.
Senator Rest.
Madam Chair and Senator Pratt, this would not just be for a day of remote voting. This would be on, this form would have to be filled out on every single roll call vote that would be taken. So
Correct.
you envision that there would, you would be, I mean, it could be done very quickly, but you would wait for those who were not in the chamber to send their form in or not, to vote remotely. And then they would be voting for themselves. It would not be proxy voting.
Correct.
They'd be voting for themselves, which is, I think, a major, I understand as a major difference. But for every vote that requires a roll call, but not otherwise, what about on a division? How would you envision a division following this process?
Senator Pratt.
Thank you, Madam Chair and Senator Rest. I think we've contemplated that division would continue to not, for remote votes would not be considered in division going forward. But again, in my mind, what I view is someone is watching the debate. They have basically a web form that they could type in A17, no, and have some sort of e-signature that, checkbox that would say they understand that they're voting under, under the threat of perjury.
Thank you for
Senator Dibble.
And that, Madam Chair, is my question. I don't know if we're going to debate or not, and I'm willing to be cut off if we are, but the question was penalty of perjury. Do we have prohibitions for perjuring ourselves in other parts of our rules, and do we have a mechanism to deal with perjury if we commit perjury as members?
Ms. Stengel.
Madam Chair and Senator Dibble, I don't recall. I'm trying to find my rules here so I can do a quick keyword search. But I don't know that there's a specific reference to perjury in the Senate rules.
Thank you, Senator Dibble. Senator Drazkowski.
Thank you, Madam Chair. Well, I would just point out, I mean, this is, like Senator Pratt pointed out, this is something that Montana does. They put really belt and suspenders on some of the, and they have limitations on times that people can, or members can vote remotely, and in that case, they use these forms, which it's still proxy voting. So it's Senator Rest was mentioning that it's still proxy voting, but it's the Senate at that point saying, under these conditions, it's okay for you to proxy vote if you fill out these forms and do this X, Y, and Z.
All right, seeing no further questions, we can move on to SR 044.
I can handle that one, Madam Chair.
All right,
That one is related to the question on division. It's, and that's exactly what it is. It just says a member voting remotely must not be counted in a division. That's the amendment.
all right.
Madam Chair.
Senator Pratt.
Thank you, Madam Chair. I'd like to present SR 69.
All right. Can we get that one distributed, please? Thank you. If you'd like to begin.
Thank you,
Senator
Madam
Pratt.
President. What SR 69 does is it instructs the Secretary to adopt procedures for remote voting. I want to make sure I've got the exact language here. And must be reviewed by the Committee on Rules and Administration within 30 days of commitments of each biennial session. So during COVID, I think, as we've talked about a number of times, we had procedures written out that were reviewed. Here's how we're going to do it. They were made available to members, and we just want to make that a standard practice going forward. Here's how the Secretary is going to be administering remote voting.
Questions? All right, seeing no questions, SR 042.
I'll take that one. Madam Chair?
Please proceed, Senator Drazkowski.
Thank you. So, Madam Chair, SR 42 relates to, and I think I mentioned this on the Senate floor, in the interim, the adoption, we found the adoption of per diems being given to members who met during the interim and were given per diem for committee expenses. And this, the example I have in mind was a commission, particularly, Madam Chair. And those, well, again, we don't need to debate this now, but, and there could be variations of this too. There's a question of whether it's a committee that's meeting during session or in the interim. That's another maybe distinction for us to grapple with as we go to this. But certainly I know some members, including myself, have a problem with per diem being given to members when they meet via computer and they don't have any additional expenses, which is the original reason for which per diems were invented. That's SR 042.
Thank you. Senator Pratt.
Thank you, Madam Chair. I would also like to offer SR 72.
Please proceed.
Thank you, Madam Chair. Madam Chair, this is a requirement that remote committee members and testifiers, in order to participate, must have both audio and video communication. I remember at one point during COVID, we actually made members show their thumbs up when they were voting, and I think we've strayed away from that and just re-implements that some sort of standard that we understand who is voting. And members are voting for themselves.
And Senator Pratt, is this related to committee?
Yes, this is related to committees.
Thank you.
Next one is SR 74. And then to be helpful to folks, then followed by the next ones at least that we have on our list are SR 62, and then SR 76, and then SR 60, then SR 75, and then SR 73. So I'll go through them again. 74, 62, 76, 60, 75, 73. So the next one, SR 74, I'm just going to read the description I have here. Proponents and opponents of a bill must be offered equal time to testify at a hearing. In determining a list of testifiers to speak on a bill during a committee hearing, chairs must consult the bill author and minority committee lead. Committees are prohibited from using randomized methods to determine a list of testifiers. And I know that some of us in the minority have had questions about how the list of testifiers was provided, and it seems that sometimes that suddenly the testifier list was full, and so certainly debate around how that testifier list is built and arrived at and agreed upon between the majority and minority in a committee, and that's what this would address, Madam Chair.
Thank you, Senator Drazkowski. Senator Rast?
Senator Drazkowski, it's my experience that some people come in and they talk on both sides. I mean, they'll say, I like the bill, but I oppose this part of it. So how would a chair know whether they're for it or against it, to be a proponent or an or an opponent? And you don't have to answer now, but it is I think, a consideration. Sometimes we don't know.
Senator Drazkowski.
Madam Chair, we're going to pull number 73 out if that's, and get rid of that one, because it's not ready.
All right.
But we're on, go, Senator Pratt's next.
Thank you, Madam Chair. I'd like to offer SR 62.
Thank you. You're doing great.
These young kids are quick, aren't they?
They are. My head is spinning, not really, but if you'd like to proceed, Senator Pratt.
Thank you, Madam Chair. And we had a bit of this discussion in the Finance Committee yesterday, that it seems like we are getting short notice on what committee agendas are going to be. Yesterday, we brought up the SRO bill, and there was a bill added at the last minute, and it was fine. It was a non-controversial bill, but what we want to do is instead of saying at least 3 calendar days, say at least 72 hours before the committee has a hearing. And as we saw yesterday, the meeting was posted with TBA. And it was about 21 hours before the hearing that the listserv went out with the agenda and the bills were identified. And all the material was made available. We're also in this saying that bills may be removed from the schedule with less than 72 hours' notice. So if something happens, if a bill author falls ill, or there's another reason a bill isn't ready for debate, we can pull that off. And then upon the agreement of the chair and the ranking member, a bill may be added with less than 72 hours. So if we take that resolution for firefighter Gao that we passed yesterday, there's certainly no reason that I would oppose putting that on the schedule. And we could continue to do it in that manner. Madam Chair, I think you heard from me yesterday that, and I understand that when we get down to deadlines and we get to other, and end a session, that it becomes a very tight and compressed schedule, but we are not following Rule 12 at this point in time, when we have more than ample time to do the proper notification, not only to the senators, but to the public. And that's the intention behind the bill, or the resolution.
Thank you, Senator Pratt.
So, Madam Chair?
Senator Drazkowski.
So our next one is SR 76. And Senator Pratt talked about that. This would suggest that to be announced or other similar non-descriptive placeholder on the website doesn't fulfill the posting requirements.
Senator Pratt.
Thank you, Madam Chair. I would then like to offer the SR 60. And then just for the staff, we'll have 75 and 73 coming up after that. But right now, we'll talk about SR 60.
Senator Pratt, that
Oh,
Senator
that's right, you
Drazkowski.
pulled off 73. So we'll just, 60 and 75 then will be the last two in this section. And then we'll have some additional.
All right. If you'd like to proceed.
Thank you, Madam Chair. This is, we think this is just clarifying language, maybe a more of a technical amendment. Currently, Senate rules state that a committee or subcommittee shall adjourn no later than midnight each day unless 2/3 of the members present vote to suspend this requirement. And we're just saying, except that a committee may extend the time for up to 1 hour past midnight by 2/3 votes of its members. So it's just, we think it's more clarifying and puts some guardrails around how much longer that committee will continue to function for the day.
Senator Rest.
Senator Pratt, would this also apply to joint rules for conference committees? Is that what you're, or just regular committees within the Senate? Is there, or maybe you don't know, but maybe Ms. Stengel does, because I don't remember myself.
I was going to ask Ms. Stengel if she could help me clarify that.
Is there a joint rule with regard to extending beyond midnight in a public meeting, which of course has become the custom not to have public meetings, but we should change that too.
Ms. Dangle.
Yes, Madam Chair, Senator Rest and Senator Pratt, the Senate Resolution 060 that Senator Pratt brought would apply only to Senate committees. There is a joint rule for conference committees about conference committees meeting past midnight. That's in here somewhere. And of course, as everybody's watching me find it, I can't find it. But there is a process for conference committees meeting past midnight that similar members can vote to meet past midnight.
And Madam Chair and Senator Pratt, I realize.
Senator Rest.
Dealing with joint rules here, but at some point they should be compatible. Just a suggestion or a question for you to consider.
And Madam Chair, it's Joint Rule 2.06, and it allows members to meet past midnight 3 members out of the 5 may vote to meet past midnight
Of each,
of each side, yes.
just saying.
Thank you, members.
Are we ready for the next one?
I am. Senator Drazkowski.
Madam Chair, I'll provide staff what I have on the list next. So SR 75 is what we're looking for now. And then following that, I have SR 32-1, and then SR 33, and then SR 71, then SR 70, then SR 50, and then SR 65. So I'll proceed with SR 75, Madam Chair. This provides that when the Senate is adopting committee reports, a member may question the adoption of a particular committee report in the face of the process that report came through the committee under Rule 12 and how our committee rules were adhered to with that particular report, and says if that member has a problem with, that they're bringing up with the process that was followed in Rule 12 with that report, that the committee report must be referred without debate to the Committee on Rules, and then following the review by the Committee on Rules on the allegations related to Senate Rule 12, the Committee on Rules Administration may then refer the committee report back to the Senate floor for adoption. That's what it does.
Senator Rest.
Thank you. And, Madam Chair and Senator Drazkowski, this is in addition to a challenge that is made under Rule 21.
Correct.
Thank you.
No further questions? SR 32-1.
SR 32-1.
All right.
Yes, Madam Chair.
Senator Pratt.
Thank you, Madam Chair. You know, with, as Senator Rest has talked about, how we operate, the tools we use have changed over the decades that the Senate has been meeting. And so this mirrors something that I've seen in the corporate world. Members and staff must not use Senate equipment, supplies, or resources for personal use, commercial, or nonprofit purposes, outside employment, or campaign activity, except as expressly provided by Senate policy. So it just clarifies and strengthens how we utilize the resources and the equipment that are provided by the Minnesota Senate for members' use.
Thank you, Senator Pratt. Senator Drazkowski.
SR 33, Madam Chair, prohibits members from authoring bills that appropriate money to a named nonprofit or for-profit entity. We saw a proliferation of those last session in a way that I have not seen before, Madam Chair, and I think it really raised the antenna on a lot of people in Minnesota as to what it was their legislature was doing. And certainly, there are questions around ethics that can evolve if a particular member issues or authors a particular bill, and we're placing our members into the cobwebs if we continue this, Madam Chair, I think is the thought. So that's what SR 33 does.
Senator Rest.
Thank you. So the second clause would prevent a description like an organization whose address is the following, or an organization that only exists in, where do you live?
Mazeppa.
Mazeppa, Minnesota. I mean, so an alternative description that could only apply to particular, either one or more, would not be allowed as well.
That's how I read it too, Madam Chair.
Thank you, Senator Drazkowski. Senator Pratt.
Thank you, Madam Chair. I would like to present SR 71.
Please proceed, Senator Pratt.
Thank you, Madam Chair. Looking at conflict of interest, it prohibits members from authoring legislation appropriating money to a nonprofit or for-profit entity governed by board members who also sit on boards of an organization to which the member or their spouse is employed or themselves a member of. This probably wouldn't apply, but I can give you an example where, as we were debating a bill in the Jobs Committee, there was a proposal to provide an appropriation to an organization that the commissioner's wife was sitting on. And we had quite a debate around conflict of interest in that scenario. And so this would just put some teeth behind that to make sure that members aren't submitting bills that, and making appropriations that would benefit them or their spouse.
Senator Rest.
Thank you, Madam Chair. Does this also preclude a member who is on the board of an organization from voting on something if they haven't done any of the rest of this stuff? And so I'm trying to read it real carefully. Maybe you already addressed that in here, but as long as they don't participate in debate or any of that, and their spouse doesn't, does that mean they can't vote on a bill that contains a provision, even though they haven't been involved in it at all, would have that? I'm on the board, kind of, not properly, so I'm getting off, of a League of Women Voters in my district, and there may at some time be voter education stuff that would be funded or given to the League of Women Voters. I don't know that they would accept it, but let's say they did. But I don't take part in it, I'm not on the bill, I don't take part in the debate. Would I be precluded from voting on it, or would the current rule where a member, like Senator Miller has done on occasion, just announces that because of rule XYZ, they're not going to be voting on something?
Senator Pratt.
Thank you, Madam Chair and Senator Rest. Right now, I'm contemplating the latter, that we already have rules on voting for bills. This goes really to more of the debate and the authoring of bills.
And authoring bills rather than just mere membership on a board that may benefit or may not benefit, for that matter, right?
Senator Pratt.
And Madam Chair, thank you, Senator Rest. So, you know, I think back to when I was an employee of U.S. Bank, where I also serve on the local board of directors for my local nursing home. It would preclude me from authoring or being a part of debate for a bill that provides funding to nursing homes, because I'm not specifically directing it to my nursing home. And just like when I was at U.S. Bank, I could vote on and author bills that were maybe good for the banking industry as a whole, but I couldn't do it specifically for my employer.
All right. Senator Drazkowski.
Thank you, Madam Chair. SR 70 is very similar to SR 71 in that, except that it, instead of labeling this situation as a prohibited activity, it would apply a standard of conduct to that behavior that could expose it to ethics questions. But it's exactly the same type of situation Senator Pratt described in the previous amendment.
Thank you. Questions? Seeing no further questions. Senator Pratt?
Thank you, Madam Chair. I would like to then introduce SR 50.
SR 50. If you'd like to proceed.
Thank you, Madam Chair. Members, when we, every year we sign for the Campaign Finance Board a statement of economic interest. But what it doesn't include is some of these memberships in nonprofit boards like my local board at St. Gert's. And we think that there ought to be that transparency, that the public and other members should know that these, you know, what other organizations we are in leadership roles for. And so this would simply say that we would create a process where it requires members to report to the secretary their membership on any for-profit or nonprofit boards.
Senator Rest?
Senator Pratt, would this include organizations in which, that are nonprofits, but they are organizations that are made up of, that have legislators participating? For example, four of us serve on the Great Lakes Commission, and we are reimbursed for expenses to a meeting or the Great Lakes Legislative Caucus, or any committee of NCSL that we would be considered some kind of board member. Would that include them, or does this, is the language here, which I haven't been able to read completely, would that preclude, not cover those kinds of groups where either the state is a member or is a legislative body like the NCEL or ALEC or however they're structured?
Senator Pratt?
Thank you, Madam Chair. Senator Rest, it would not include any organization where you were appointed based on your role of being a senator. So I know that we all sit on various roles.
That was not my question.
That was not your question, and that's what I'm trying to think through, and maybe Ms. Stengel can help me with the language as it's drafted to answer your question, because I have a thought in my mind, but I want to make sure that I'm addressing it in the correct way.
Ms. Stengel?
And Madam Chair and Senators, I'm not sure that the language clearly answers that question.
Okay, just the thought.
All right.
Madam Chair, I'd be happy to continue the conversation with Senator Rest.
That is excellent. Thank you. Senator Drazkowski?
Thank you, Madam Chair. While the staff is gathering up SR 65, which is our next one, there's 10 after that I have on the list, Madam Chair, and I'll go through those for staff so they have them. Those are SR 38-1, SR 48-1, SR 61, SR 57, SR 45, SR 46, SR 67, that's 67, SR 68, SR 63, and SR 64. So SR 65, Madam Chair, relates to an item that I brought up last year when we were addressing the temporary rules. In 2022, a law was passed by the legislature and obviously signed by the governor that prohibited lobbying activity under certain conditions. That's outlined in Section 3.084 of Minnesota statutes, and that law directs the House and the Senate to adopt rules to effectuate the law. That's what the law says. We have not done that. I don't know if the House has done that yet, but this would do that. This would effectuate the law. This would have the Senate following the law to put into its rules a procedure for the law to be followed. And just quickly, what it does, just for your, is on 1.18 and 1.20 of the amendment. A member may submit a complaint to the Ethics Committee, and then the subcommittee must investigate the complaint. It's pretty simple and straightforward, but I hope that we can get that into the rules. Thank you, Madam Chair.
Thank you, Senator Drazkowski. 38.
Thank you, Madam Chair. I'd like to introduce Senate Resolution 38. And I don't know if Mr. Bodden would like to weigh in on these. This would place into Senate rules, with the approval of the Committee on Rules and Administrations, that they may secure bids and enter into contracts for printing of bills and binding of the permanent journal, secure bids and enter contracts for remodeling, improvement, and furnishing of Senate office spaces, conference rooms, and Senate chamber, along with a number of other items. And it clarifies that, oh, wait a minute, Madam Chair, I got 48 instead of 38. I'm speaking to the wrong.
Yeah.
That's not
I'm speaking to the
48.
next one. I wanted to do 38.
We'll set aside.
Looked a little off on that.
Yeah, we have the wrong amendment or the wrong language in front of us, so we'll move
Why
to,
don't we let Senator Drazkowski talk about SR 48, and then I'll come back to 38.
that's a great idea.
Madam Chair, I don't know if I'm more prepared than Senator Pratt to talk about this one.
I can
Okay, so SR 48-1, it says the secretary may enter into contracts, any contracts in excess of a specified dollar amount must be approved by the chair of rules and the minority leader. Approval of a contract can be rescinded if it does not violate the terms of a contract. And I don't know, I don't know if Ms. Stengel could give any better context on that than I, or maybe Senator Pratt can.
Ms. Stengel.
I apologize, Senator Drazkowski. We're looking for the missing amendment. Can you repeat your question, please?
Can you describe it any better than I did, Ms. Stengel?
I apologize, I wasn't listening to your explanation.
If you would just describe it for us.
Yes, I can do that.
Thank you.
We are looking at the SRO 48-1, is that correct?
Correct.
I will fully disclose how little attention I was paying, I apologize. Madam Chair, members, the SRO 48-1 is based on the idea from the interim resolution that is passed every year. It includes a provision that allows the Secretary of the Senate to do various things during the interim. Let me make sure I'm looking at the right provision here. And one of those things is to approve contracts. And you'll see most of the language at the beginning of this is identical to the provision from that interim resolution, including approval of entering into contracts for printing of bills and bindings in the journal and those sorts of things. But if you turn to the back of the page, starting on line 2.2, there's some changes to what's in the interim contract, including approval of contracts in excess of a dollar amount to be determined. Under the current resolution, it's $10,000. It requires approval of the chair of the Committee of Rules and Administration and the minority leader. The current practice is the chair and another member of the committee. And then there's a process that allows termination or withdrawal of the contract of either of the party, assuming the contract allows for withdrawal or termination. It requires the Secretary of the Senate to determine what that process is and to provide notification of what that process is. And then there's a time period that's to be determined to allow the Committee of Rules and Administration to take action to ratify that contract going forward. And if that doesn't happen, then the contract is withdrawn from or terminated.
So, Madam Chair,
Senator Drazkowski.
it would provide that this would be ongoing in our rules, and we wouldn't have to be deliberate about doing the interim resolution for this each time, and it would be an ongoing responsibility of the Secretary.
Thank you. Senator Rest?
Thank you. Senators Pratt and Drazkowski, in one of the former amendments or proposals you made, you referenced a precedent that you supported from the state of Montana. And I wonder if this and other similar ones that you are proposing, do they have any connection with like best practices, either from CSG or NCSL or any other national organization that looks at, or maybe some of the, or Pew Charitable Trust or something that looks at efficient and effective ways for legislatures to proceed in passing laws. That would be very interesting, I think, as you present, whichever ones you choose to present for debate. If you had some information like that, I mean, obviously, these can come out of your own head, too, but I think that would be very interesting to see if it's, some of these things have been recommended as best practices by national organizations that look at how legislatures operate. Thank you.
Thank you. All right. And just for the record, we are going through a lot of amendments and we're moving, or language, it's not even amendments, but language, and we're moving fairly quickly. And I want to say thank you to all the staff and to the members for their patience, including Ms. Stengel, who was looking for an amendment and paying attention to our work. All right. I think next is 61.
Well, thank you, Madam Chair. Well, maybe I'll just describe SR 38 very briefly, and then maybe we can review it next time, but, oh, you're going to have it. I'll wait then.
All right.
Madam Chair, I'd then like to propose SR 61. Madam Chair, as you know, Senator Rest talked about, we have staff on the floor with members who, you know, if members can have water, they should have water. We have our staff on the floor on a constant basis, and yet our rules say they may only be, and I had it right here, at the request, at the invitation of a member, and I think we should just recognize that our staff should have access to the Senate floor as they are supporting all the members and the work of the committee, and then move some of the other folks who have automatic access to be at the invitation of a member. And so just to, I think, modernize and update and restructuralize who's on the floor during our debates.
Thank you. Senator Rest.
In this proposal, would you consider interns under the definition of Senate staff?
Senator Pratt.
Thank you, Madam.
They're currently not. No, maybe they are.
Thank you, Madam President. And Senator Rest, I would, and I would also, you know, I had the same thought when you were presenting one of the amendments about staff on our pages, and I didn't know if they would be classified as staff or not, but I'd want to make sure that.
Well, they work on something.
Right.
But I think.
But I think our interns
You know,
should
just-
have, that's part of the experience.
Just maybe have a less general word than staff. That would be, I would ask a question. Have you considered having a more specific definition of staff?
Thank you, Senator Pratt. Senator Drazkowski? Oh, I'm sorry, Senator Dibble.
Just a quick question, this may not, and maybe I missed it. What is the effect of the change of moving the constitutional officers, ex-governors, et cetera, down to 15.3 and adding the qualifier personally admitted by a member of the Senate?
Senator Pratt.
Thank you, Madam President and Senator Dibble. When we're debating a bill, when we're in session, it's a very busy place to be. I think that there are enough opportunities for us to have that conversation with a constitutional officer. And I would think back, I believe there was a former member who was on the floor during a debate when they were intimately involved in a bill that was under debate, and they should be admitted with the invitation of a member, right? The floor is for our work to get done. And if a member wants to have a constitutional officer, then they can invite them into our chamber. And that's fine, but otherwise, those conversations should be happening outside the chamber.
Senator Rest.
Madam Chair and Senator Pratt, I don't recall anyone inviting the governor in to watch our debate. Right?
No.
And I won't express an opinion, but I just wanted to know if you recall any instance in which the governor of this state has stood in the back next to us and or staff to watch a debate.
Madam Chair.
Senator Pratt.
Thank you. Madam Chair, I do not recall that happening. I'm not saying it didn't, because sometimes, as you know, I get a little wrapped up in what I'm doing. But I would say that I don't know that a governor should be standing in the back during our debates unless they've been invited in by a member.
Senator
We're
Rest.
not debating, even though I may agree.
Senator Drazkowski.
Madam Chair, thank you. I don't know if we formally submitted SR 38-1 yet. We talked about it. Did it come yet? SR 38-1?
Still in works.
Is it?
It's not here yet.
Oh, it's still
SR
coming.
38.
We're delaying it until it's
Oh,
ready.
thank you. Okay. So then we're up to SR 57, and then SR 45 is on deck.
Thank you for the on deck. 57, then 45.
Then 46, then 67. I'm just working for my notes, Madam Chair. SR 57 clarifies engrossing of amendments and amendments to the amendment.
Start making my head spin. Please proceed.
I'm going to have Ms. Stengel talk about this one.
Ms. Stengel.
Thank you, Madam Chair and Senator Drazkowski. This is a complicated situation that happens sometimes on the floor because we don't live engross our amendments. When amendments are adopted and then amendments to amendments are adopted, you can still further amend both of those, but you can't easily see what's already happened. So sometimes we find ourselves in a situation on the floor where we don't quite know what's happened. And so this just clarifies current practice, what already it says in Mason's, that an amendment to an amendment may be adopted once it's already been adopted. This also solves the problem of you can't amend an amendment to an amendment, so you can't go three deep. So if you're trying to amend an amendment, adopt it, and then you can go back and amend it again. So anyhow, it's a complicated and confusing situation. Sometimes tensions run high, and then people pull out their Masons. So it's easier just to put it in the Senate rule to clarify what's going on.
Senator Drazkowski.
Madam Chair, thank you. Thank you, Ms. Stengel. I've just had an idea, Ms. Stengel. I wanted to run this by you. What if we preface the language there on 1.21 with words to the effect of the resulting language affected by, to make it clearer. Would that be helpful, or am I thinking something else?
Senator Drazkowski, this is language that we worked closely with the engrossing Secretary Mapes on, so I'd like to have that conversation with her as well, so
Okay, I just think if we preface it somehow to give a little context up front, it will make it clearer for us reading the rule down the future if we adopt it. Thank you, Madam Chair.
Thank you, Senator Drazkowski. Senator Pratt?
Thank you, Madam Chair, and members, I'd like to introduce SR 45. This might be the simplest one we deal with all day. This basically says that all documentation on a bill must be in permanent ink. We've heard that members have signed in pencil, erased it, that we want to make sure that there is a standard that pencil is not an acceptable way to be documenting either your authorship or the result of action taken on a bill, or that all of that official action must be done in permanent ink.
Thank you, Senator Pratt. Senator Rest?
So Senator Pratt, do you really mean signatures? Or this rule says thank you, must be written in permanent ink? Do you mean, would you consider saying signed?
I'm sorry, I didn't.
Would you consider saying signed in permanent ink rather than written? Because I have heard of the practice of members or staff signing a member's name that is not the member.
Senator Pratt?
Thank you, Madam Chair, and Senator Rest, I'd be happy to have that conversation with you offline.
Please
We
do.
kept written because it was in the existing rules.
Please do, thank you.
Thank you, Senator Pratt. Senator Rest? Next is 46, I believe, SR 46.
Yes, SR 46, Madam Chair, thank you, and followed by 67, 68, 63, and finally 64. SR 46 says a bill proposing constitutional amendments must be referred to rules. That's what it says.
Madam Chair.
Senator Drazkowski, excuse me, Senator Pratt.
Thank you, Madam Chair. I believe this is the current practice of the Senate. We just wanted to memorialize it in the rules.
Thank you.
And then, Madam
Madam
Chair.
Oh, Senator Rest?
Oh, sorry.
You're not suggesting that the Committee on Rules and Administration be the committee of origin, however. Is that correct?
If you, Madam
Senator
Chair,
Drazkowski?
Madam Chair, if you read the rules, the answer, or if you read the language, I believe the answer is no. It says before passage, it needs to be
Just
sent to.
before passage?
Yep,
not-
thank you.
Not original, thank you.
And then, Madam Chair.
Senator Pratt?
Thank you. I'd like to introduce SR 67. Thank you.
How many trees did you cut down, huh?
Okay. Senator Pratt, when you're ready.
Thank you. We're just making sure the numbers match. Madam Chair, this strikes the general fund target announcement by the Majority Leader or Finance Chair. Senate budget targets must be adopted by the Committee on Rules and Administration before they're in effect.
Thank you, Senator Pratt. 68. Senator Drazkowski.
I have to read the language, Madam Chair. Here it comes. Okay, this amends Rule 7.2. dealing with an announcement. I don't know the Senate rules as well as many of you do. This is budget target announcements. It says, so it adds on to our existing language, says the announcement must reflect only the Senate's general fund budget targets. It cannot reflect the budget targets of the House of Representatives. A public announcement of budget targets made by a member of the House of Representatives or the executive branch does not constitute a public announcement under this rule. And I believe this was drafted in response to some lack of clarity among what the Senate's target was specifically last session, Madam Chair.
Thank you, Senator Drazkowski. Senator Rest.
Thank you very much. What if the House and the Senate agree on joint targets? Would the announcement from the Senate, even if it's a joint target, include only mention of the Senate, even if it's an agreement between the House and the Senate to have joint targets?
Senator Drazkowski.
I think we'll take that one back to the workshop and Senator Rest have that conversation.
Okay,
Yeah,
thank you.
I think it's a good question, and let's put it in the workshop and go back.
Thank you.
Thank you, Madam Chair.
Madam
Senator
Chair,
Pratt.
not to be debating this, but Senator Rest, I believe the premise of this is that the targets that we're setting are Senate targets, and while they may be equal to those in the House, the Speaker should not be announcing our target.
Thank you, Senator Pratt.
Madam, I keep wanting to call you Madam President. Madam Chair, I would like to offer the A63 amendment.
Proceed when you're ready,
Thank
Senator
you,
Pratt.
Madam President, or Madam Chair. I knew I was going to do that.
And wait for a crown.
So often, we hear, our staff lets us know what's coming up on special orders, but it's often not announced to the public. There's no way for members to look up what's coming up. And so what this says is, to the extent practical, a list of bills designated as special orders must be made publicly available on the Senate's website prior to convening that day.
Senator Rest.
Thank you. What about a bill that is, would be on that list that is then pulled from special orders? How early must that announcement be given, I would ask you to consider?
Madam
Pratt.
Chair and Senator Rest, I would think that it would follow much like we talked about in the committees, where there's no prohibition from pulling a bill from special orders. It's putting a bill up for action that we're most concerned about.
Thank you.
Thank you, Senator Pratt. Senator Rest.
I think Senator Drazkowski is the last one.
The last one, Madam Chair, is SR 64,
38.
and 38 's still coming. Or we might be able to describe 38 and then put the language on the pile, Madam Chair, if that works.
If you'd like to proceed with SRO 64, Senator Drazkowski.
Okay, thank you, Madam Chair. SR 64 strikes in Rule 36.11 or at an earlier agreed time by a majority of the whole Senate.
What's this?
So this is about the debate on a report of a conference committee. You can read the language there.
Senator Rest.
So does this mean that even though we don't have it in front of us, if 34 members say we want to talk about something that's not in front of us, or a conference committee report, that we would be allowed to proceed to do so?
I think,
Senator Drazkowski.
I think, Madam Chair and Senator Rest, I think this was put together,
Or not allowed, I'm sorry, not allowed.
I think this amendment was drafted in response to frustration that members have by the speed at which the Senate was operating around these conference committee reports in past sessions. And it just seems like it's responsible for us to find a way, whether this is it or some other way, to make certain that every senator knows and can see and understand what is being debated before we move forward and suddenly we're moving too far into debate or a vote.
Thank you.
Thank you, Senator Drazkowski. So we're pausing on
Madam
38.
Chair, I'll just talk about SR 38 very quickly, and like I say, if Mr. Bodden wants to weigh in, but it places in Senate rules some boilerplate resolutions adopted prior to every interim. Rules may study and investigate, rules may fill vacancies, rules must set comp and appoint employees, and allows the secretary to pay election and litigation expenses. We think this is a fairly technical amendment.
And just like that.
And when we get the language, I'm sure Senator Rust will have a question.
We're not debating,
Yes, ma'am.
but I'm writing yes or no on each one.
That's contemplation.
I'm sure when we have our offline discussion, there might be some debate.
Senator Pratt? You do?
I think I've described it, and I'll just be open to any questions.
Okay. Now I'll invite Secretary Bodden if he has any questions.
I can't read that fast. I do have a question.
Senator Rest.
So does this proposal come also as a proposal, as a best practice from some other body or national organization?
Madam Chair and.
Senator Pratt?
And Senator Rust, I don't know. I think we just looked at it as what we thought fit ours, and we can certainly take a look.
Senator Drazkowski.
Thank you, Madam Chair. If it's helpful for Senator Rest, of the amendments that we offered, the only one that I know of where we looked elsewhere to find these was that Montana example.
One. Okay,
That's the only one I'm aware of.
okay.
Thank you, Madam Chair.
Are there any other ideas?
I do have a.
Senator
another
Rest.
question. How many of the ones that you've presented today have been offered by either caucus in previous adoption of rules? Many of them, few of them, or you don't know?
Madam Chair and
Senator
Senator Rest,
Pratt.
I think I could say that I know that some of them were. I recall quite lengthy debate, but I couldn't tell you if it qualifies as few or many.
Just curious. I like some.
All right. I want to say thank you for
This has been great.
what is, not a debate, but a really thoughtful opening on the question of rules. And for the work to put a lot of ideas in front of us, good ideas from both sides. We will come back in another subcommittee. I'm thinking through the process, but don't want to talk about it yet because it's not clear to me, but we'll talk with members on the next steps so that we all come into the next meeting with clarity about how we're going to operate, because there's a lot of material here. I want to give all of it its due. And as I hear you already setting up, it'll be useful to talk to each other between now and when we meet again. And our staff, of course, are available, Ms. Stengel, Secretary Bodden, and others, with questions that any of us might have. And without any further action before us, members, I'd like to say thank you again, and please enjoy the rest of this sunny day. And with that, the subcommittee is adjourned.